Ladies? Ladies? Thank you. Well, we have a panel about economists, and what is the contribution, or what could be the contribution of economics and economists to the litigation, to the mass litigation? If we go back to the impressive picture from the morning of the cars in the desert, this is this is something that economists will look at and will ask himself about the waste of resources. I mean, is it really a good result for the society to take all these cars and put them in the desert and produce new cars? And you know, there is a real great negative impact on the environment of producing new cars. So is it really a good solution? Maybe the European way is better. So, and then I ask myself, should this cost-benefit analysis be part of the litigation process? And how could it be done? Now, much of the work expert economists submit to courts is trying to establish the counterfactual, not the factual, but the counterfactual. And I think from my experience, it is not so naturally and not so well fitted into the adversarial process. So we will try in this panel to see what use can be for economists and economics and how is best to be used. The first speaker will be Hal Singer. Hal is an expert in antitrust and regulation. He has researched, published, and testified on competition-related issues in a variety of industry. And he will speak about the question of what economists have in the toolkit with respect to the question of common impact of the class certification. Please, Hal.
Thanks, Menachem, and thanks to Ariel for inviting me here. I'm very excited to be here for this topic, but to be honest, I probably would have flown to Israel and spoke at any gig, just have an excuse to come to Israel. It's my first visit to the Holy Land, which at my advanced age and religion makes me a very horrible person, but after listening to the speech, I hopefully you won't think I'm also a horrible economist. There are a few more jokes in here too, and whenever I give you the nose cue, it's a signal to laugh. I should tell you, my staff came out here too for the trip. Omer and Catherine, and Omer's mom came, and we're having dinner at Omer's mom's house tonight. So this has to be good, or I'm screwed. So the subject of the panel is class certification and the role of economists, and I thought that I'd talk about something that I kind of do for a living, which is helping plaintiffs establish class-wide impact using various tools in the economist toolkit. The problem, of course, let me just tell you what common impact means to me, and that's the notion that all or almost all members of the class were injured by the challenge conduct, and whether it's a conspiracy in a Section 1 case or restraint of trade in a Section 2 monopolization case. But the problem is that the primary empirical tool in the economist toolkit is regression analysis, and as Brian laid out earlier, regression analysis speaks to average effects, which by themselves are not sufficient to prove common impact, at least under US antitrust standards. So what is a poor economist to do, or even a rich economist? Sorry, I had to work in one Tevye reference for this audience. I'm still a horrible person. There are three approaches to solving this puzzle, and all three involve what I call the basic regression plus. So the basic regression, right, is that model that maps the characteristics of an industry, the supply characteristics, the demand characteristics, into the price, and tries to isolate the effect of the conduct. What is the incremental explanatory power of the conduct on price? Or in a monopsony case, it does the same thing, but with respect to wages. To get across the finish line, however, one needs to do this basic regression plus, and I'm going to talk about quickly three methods that I use to get across the finish line. The first approach is the basic regression plus a pricing structure. Now, a pricing structure, as the name suggests, implies that all prices are tied together through some common element or elements, such that proof of a generalized price effect implies that all or almost all class members suffered the same price effect or something similar in the same direction. Now, of course, I didn't invent this approach, but I have published articles on it, and if you're interested in the pricing structure approach, I commend you to read a piece I did in the George Mason Law Review, and I did a piece for the ABA as well. And I've used the pricing structure approach in my litigation practice. Now, a pricing structure can be proven using record evidence, statistics, or ideally both. Examples of record evidence that would speak to a pricing structure would be an internal memo, for example, from a defendant suggesting that the way that they get to their final prices is to begin with a list price and then to negotiate individual rebates. Or in a monopsony case, evidence showing that a firm was concerned about issues of internal equity when setting wages. That would support the notion of a pricing structure on the wage side. In addition, a pricing structure, a wage structure, can be established statistically, for example, by showing that wages for a given employee can be explained by movements in the wages of other employees, or by common characteristics such as job titles or experience. That's enough with the first approach. Moving to the second, I call this the basic regression plus interaction terms. So what do I mean by this? Well, this means we allow the effect of the challenge conduct now to vary by buyer. And mechanically, the way this is achieved, and everyone's eyes will roll back into their head now, is by introducing what we call buyer dummies or buyer characteristics into the regression model, and then interacting those dummies with the conduct term. And probably not going to make sense at this level, but that is the method in the madness. But what that does is it allows the effect of the conduct to vary by buyer, and then we can ask questions as to whether or not that effect, that individualized effect, was statistically significant and in the right direction, and if so, for how many of the class members. So now instead of, say, finding an average effect of 5% inflation for the entire class, we can say that Mary suffered 4% price inflation and Tom suffered a 6% price inflation. Of course, I didn't pioneer this approach, but I have published articles on point with my business partner, Kevin Caves, in Research in Legal Economics, if you're interested in following this thing further. The third approach to proving common impact involves the basic regression plus individualized predictions. So here, once we've estimated the basic regression model, we can go try to make a prediction what each buyer would have paid in a but-for world. And this is conditioned on that buyer's individual characteristics. The only thing that we change now is that where that dummy was in the original model was set to on, right, in the presence of the conduct. We're now going to, before we make this new prediction, we're going to set it equal to off, and then we're going to compare the predicted price of a given buyer to the price that buyer actually paid. Or in the context of monopsony case, again, we can do the same thing with respect to a worker. Here, you can think of if the conduct was measured as what we call the foreclosure share, what share of the market was subjected to some exclusionary provision that foreclosed rivals from access to these key workers, you could say, I'm going to make a prediction for how much that worker would have been paid in the but-for world by setting the foreclosure share down to a level that would be acceptable under antitrust law. So that's the good news. There are at least three solutions to solving this problem related to the deficiency of average effects. But like any empirical method, none of these three bullets I've outlined are bulletproof. And if time permits, I would like to quickly just list through some of the infirmities. So the first approach, again, basic regression plus a pricing structure, is what I would call an indirect proof. That is, we're never going to be able to show the judge the direct connection between the conduct and an individual's price. We're hoping that the judge will see the nexus between the basic regression, the generalized effects, and the individual effects that come from the pricing structure. The other impediment to winning through this approach is that even if there's a pricing structure, there's no guarantee that an individual buyer didn't get a sweetheart deal or wasn't able to offset the effect of the conduct through its countervailing power. Quickly on the second approach, basic regression plus interactions. The problem here is that it can only be deployed under very limited circumstances. That is, in order to get an individual coefficient for any buyer, you have to have two conditions. They're not always met. One is that you have to have the buyer transacting in the clean period and transacting with the defendant in the dirty period. And a lot of times you're going to have new buyers just showing up for the first time in the damage period, and so you'd never be able to speak to their injury with this method. The other problem too is that, and there's a little dirty secret of statistics, is that to find statistical significance at a conventional level, you need a lot of transactions for each buyer. So if you only have, say, 5 transactions in the clean and 5 in the dirty, even if that buyer suffered at the average effect, it's going to be hard to demonstrate empirically that the effect for that buyer was statistically significant. And then finally, moving on to the third approach, basic regression plus individualized predictions. The success or failure of this method is going to turn largely on the size of the average effect. It's also going to turn on how well the model does at predicting. And just in summary, a very, very quick notion is that if the model does a poor job predicting, such that the R-squared of the model is low, and the residuals are high, the residuals are the errors in predictions for any given buyer or worker, then it's going to turn out that this model will suggest that even in the presence of a large average effect, that many of the buyers were able to escape injury. So I'll leave it at that, and I'm happy to answer any questions that you guys might have.
Thank you. Our next speaker is Richard Kaufman. He's a partner and co-chair of the antitrust practice group at Cohen Milstein in Washington, D.C. And he has served as court-appointed lead or co-lead counsel for plaintiffs in several landmark antitrust class actions, including the case which resulted in the largest price-fixing verdict in the US, with more than $1 billion dollars. That's correct, yes. Okay, now the question or the issue Richard will talk about will be the standard, or what should be the standard for evaluating the expert testimony.
Good morning or good afternoon. I can't tell quite which it is. Thank you, Menachem, for that kind introduction. As the only non-economist on the panel, I thought I'd talk about the standards by which courts should evaluate economic evidence in the context of class certification. And I'll try to use this PowerPoint, but I'm not very good at it, so please bear with me. I may bag it eventually. Oops, I might bag it now. All right, let's skip the PowerPoint. Let's see. So as a lot of people have discussed earlier today, and I won't dwell on it, class actions in the United States are governed by Rule 23. Rule 23 has several requirements: numerosity, common questions, typicality, adequacy, and predominance and superiority. The requirement where expert economic evidence comes up most frequently, it's okay, I don't need it, is in the context of predominance. And that's where we have to show that common issues common to the class, will predominate over issues unique to certain individual class members. And expert economists can help us do that. And my experience is limited to antitrust cases, so I'll talk about that because that's what I know. In antitrust cases, plaintiffs must generally show that class-wide impact can be assessed using evidence common to the class. And usually that includes expert econometric analysis, as Hal discussed, to show that each class member, or all or nearly all class members, were injured. So admissibility of expert testimony is governed by Federal Rule of Evidence 702. And I won't dwell on that too much, but I'll just say that it has to show that the testimony is based on sufficient facts or data. It has to be the product of reliable principles and methods, and the expert has to have reliably applied those principles to the facts of the case. Plaintiffs in antitrust cases will generally argue that if expert testimony is admissible, then that's enough, and that the judge should find that if the expert testimony meets the requirements of Rule 702 and of a case called Daubert, which establishes standards for courts to analyze the reliability of expert testimony, that testimony should be sufficient to get the class certified and send the case to the jury. Defendants will often argue that, no, it's not enough for the plaintiff's expert's testimony to be admissible. You need to compare that testimony to the testimony of the defendant's expert, who will try to poke holes in the plaintiff's expert's analysis, and the judge needs to decide which expert is more reliable. And if the plaintiff's expert is more reliable, then you can certify the class. But if the judge finds that the defendant's expert is more reliable, then you should not certify the class. So the plaintiffs tend to focus on methodology and the question of whether the plaintiff's expert relies on plausible or admissible methodologies, and whether common evidence is capable of proving the requisites for class certification, not necessarily whether plaintiffs have at that point proved the prerequisites for class certification. The defendants will advocate a battle of the experts approach, which says that the court must not only determine at class certification that the expert evidence is admissible, but also whether it's persuasive, and in fact more persuasive than that of the other side, of the defendant's expert. So this is an issue that tends to come up in our cases, where the plaintiffs will argue, Your Honor, if you find that our expert's testimony is admissible, and you find that, if believed, it would show that all or nearly all class members were injured, then you should certify the class and let the jury decide which side's expert is more persuasive. The defendants will argue, no, Your Honor, you have to decide whose expert is more persuasive in order to decide whether the class should be certified. This is an issue that can go both ways in American courts. In most cases, it has gone the plaintiff's way, and the court has said, it's not my job to decide which expert I believe. As long as both sides' experts submit admissible testimony that's sufficiently reliable, I'll send it to the jury, and the jury will decide. And I would suggest that view, the plaintiff's view, is more compatible with the judge's traditional role of opining on the law and instructing the jury on how to find the facts in the context of the law, and the jury's traditional role of finding the facts. It should be the judge who tells the jury what evidence they may consider and the standards under which they should consider it, but the jury should decide which evidence it finds more persuasive. Thank you.
Thank you, Richard. The next speaker is Kimela Shah. Kimela is from Auxerre, member of the Transport Modeling and Litigation teams. Her work involves applying quantitative and developing analytical models. And Kimela will speak about one stage earlier, when you evaluate or try to evaluate possible claims and what economists can do in this primary stage.
Thank you, everyone, for choosing this panel session. Thank you to the organisers as well. We heard this morning that the UK has had a mechanism for collective redress for centuries, but in the Competition Appeal Tribunal, there's only been 2 cases heard and there's 2 pending, so we'll focus on those. Having been involved in these early cases, and despite the regime being new, there are still some valuable insights that we can discuss. So as I see it, there's 2 main questions in terms of estimating and quantifying damages in class actions. The first is, what is the method for estimating the size of the claim, and the second is, what is the likelihood of being able to do this on a class-wide basis? For the method, there's 6 stages. The first is looking at the theory of harm and looking at the actual infringement. The second is the value of commerce. Third is overcharge. Fourth is pass on. Fifth is the volume effect, if relevant. And 6th is interest. Don't worry, I'm not going through all of them in detail. So in terms of the theory of harm, it's important to have a clear and precise theory of harm, even where there's a follow-on action and there's a decision from a competition authority. If there's a price-fixing cartel, there may be a presumption of harm, but where the infringement was not such a hardcore infringement, it's important to articulate this theory of harm. This helps you to understand the mechanisms that the harm is creating, and therefore the type of analysis that you need to identify in order to identify the harm. Ultimately, this is to ensure that you are identifying the harm caused by the infringement and not by some other factors in the market. If your theory of harm is different across the class as well, then it means you're able to structure your analysis appropriately. So secondly, the value of commerce. Where you have an opt-out claim, you need to be pragmatic about the type of data that you can use prior to certification and prior to any or very much pre-action disclosure. But then you also need to consider where this data will come from after certification, where you expect to get the disclosure from, and if it's appropriate to cover the whole class. So the third step, overcharge. As we heard from Brian this morning and from Hal, econometrics is an approach for estimating damages, but there are two other approaches, or broad approaches, which could be appropriate in class actions. So one is the financial analysis-based approach, where you use financial information on comparator firms or industries. The question here is finding relevant comparators, and it's difficult to see how you can operationalize this on a class-wide basis. So perhaps the focus is to shift on looking at financial information on the defendant to try and estimate what the defendant should have looked like in the counterfactual. If anyone has any experience using these type of models in a class basis, that'd be very interesting to explore. The third approach is market structure-based approaches. So these models are rooted in economic theory, so IO models, international industrial organization models. They rely on inputting assumptions to calibrate these models. And the job here is finding a model that fits the relevant market and the relevant infringement. Within all of these, there's the challenge of showing that the data does exist, can be obtained, and estimate harm on a class-wide basis. So the fourth element is pass-on. So in the UK, we include pass-on in the damages calculation. As we heard earlier, defendants can suggest pass-on exists and could ask claimants for this information. In a class-wide approach, this will be very interesting to explore to see what kind of discovery you can get from class members. If we turn this question around and look at claimants at the start of a claim and trying to build a claim, if a claimant's putting together a claim from a direct purchaser class, they also need to consider the question of pass-on. So if you're looking at an opt-in, you may have some expectation for your class members for the amount that they were harmed by and how much money they're entitled to. If you're looking at an opt-out, you may have funders who are interested in the size of the claim. And it seems odd then for claimants to not look or consider the question of pass-on and how you can consider this on a class-wide basis. 5 is volume effect. This is relevant if you have a class of businesses who have incurred the harm and passed on some of the harm, and thinking about this on a class-wide basis would be very interesting if you've got an opt-out class as well, especially that covers a vast number of industries and different groups. And the 6th is interest, so you can either make this very complicated or very simple, but we'll park that one. So the role of the economic expert is to, in my opinion, is to consider the whole picture of damages quantification, and that includes all of these steps, and ultimately the challenge of trying to link this up on a class-wide basis. So welcome any questions on that.
Thank you. Okay, we will open for questions.
I just want you to comment, if I can, on Rick Kaufman's presentation of this question of what standards should the court use when evaluating claimant, plaintiff, defendant expert, and defendant expert at the certification stage. And, he explained very clearly and eloquently how in the US approach it's influenced by the fact what should be left to the jury, whereas only the judge is doing the certification. And I can fully see that. Of course, the US is almost unique in having these cases tried by jury. For all the rest of us, we don't have juries in these cases, so that policy rationale really doesn't apply, and we've got to think of a different one. when we crafted the approach in the Competition Appeal Tribunal in the UK, where we introduced these class actions, we rather like in this conference where we're all listening to the experience of different countries and learning from each other's experience. So we sought to learn from indeed the US experience, and more specifically the Canadian, because Canada has full cost shifting like we do in Europe, and therefore costs being such an important aspect of this, perhaps a bit closer than the US one. And we were rather concerned not to develop certification into a mini trial, which is the approach where you'll have to hear both sides' experts tested and decide which is more persuasive than the other. But to try and keep it shorter and quicker and therefore cheaper, and therefore took the Canadian approach of looking at whether the plaintiff's expert methodology seems sustainable and whether one can be satisfied that the data is available, not gathered yet, because that's for a later stage, but available such that that methodology could be put into practice if certification is granted. And it's really a policy choice of what degree of cost and how extensive and expensive do you want the certification stage to be.
I have a related question to that, really for Richard, and if I can put Judge Dow on the spot a little bit. We have an American judge here. It has always seemed to me that there's a difference between the battle of the experts when the plaintiff's expert is saying, say in an antitrust case, the price effect is uniform and it's, $10 a person, versus the defendant saying, no, it's different, right? Or alternatively, if the dispute is, plaintiff is saying the price effect is uniform, and the defendant is saying price effect is not uniform, you've got winners and losers, and there's no way of telling which one's which. That to me seems to be the more complicated issue in the class certification setting, because if the plaintiff wins, then the plaintiff wins, right? They win, they show the price effect, they show it's uniform. If the defendant wins, they've only established that the price effect isn't uniform and really can only get a decertification of the class in that setting. So I'd be interested to hear your thoughts, and Judge Dow, if you wouldn't mind chiming on that.
Yeah, that's the, let me actually first address your question briefly. The Canadian approach used to be the American approach until recently, and then starting with a case by the famous Judge Sirica, hydrogen peroxide, the American court started to take a much more rigorous look at class certification and moved away from can the plaintiffs identify a methodology and data that they could use to show class-wide impact to actually having them show class-wide impact at the class certification stage. So the Canadian and the US approaches used to be the same, and the US has gotten more involved as time. And then to address your question, that's the most difficult embodiment of this issue of how far do you go at the class certification stage and having a battle of the experts. I think what I would say is still, I think it's the judge's role only to determine whether both experts' methodologies are reliable and supported, and not to resolve that battle of the experts at that stage. And I realize that the only remedy then may be decertification after trial, but I still think that it's not the court's job at the class certification stage to resolve those disputes on the merits between the experts, other than to find that they satisfy Daubert and Rule 702.
So I was a defense lawyer before, and I wrote a lot of Daubert motions in my defense lawyer posture. And as a judge, I find it's very different, actually. And I mostly let the experts in. And I think you've got it exactly right. I think that's my take on it. So Daubert talks about the difference between methodology and conclusions. But the conclusion still has to be supported by the data. And that's when in the early days of Daubert, plaintiffs would just come in and say, well, I have a different, you're not supposed to look at my conclusion, you're just supposed to look at my methodology. And the Joyner case, which is the second in the Daubert trilogy, actually I think tied that up very nicely, because the Joyner case says, it's true that it's the jury to evaluate conclusions, and it's for the judge to evaluate methodology. But your methodology has to lead you logically to your conclusion. And if there's a gap in logic between your methodology and the conclusion, then it doesn't fit the case. And that may be again, at the certification stage, we're not trying to evaluate the ultimate question. We're really trying just to evaluate whether the methodology satisfies Daubert and Joyner and Kumho-Tyre and all the other cases in that line of cases. And to me, I think you have it right. Your analysis is right. The judge isn't supposed to sort out conclusions. The judge is just supposed to make sure that the conclusion is supported by the connective reasoning from the data to the conclusion. That's really what, and if you get through that, then you've gotten through whatever stage it is. Class certification is different than the merits, although you're right. And I mean, Judge Sirica is one of the giants in this whole area, and if you're going to read cases other than Judge Posner's, you should read Judge Sirica's, because Judge Sirica was the chair of the advisory committee, the standing committee, which is the boss of the civil rules committee I've heard a lot of, and someone who's thought very deeply about this and also writes beautiful academic opinions. You'd really enjoy reading them, actually. But that, I think your analysis was exactly right. And judges aren't supposed to decide between conclusions. Judges are just supposed to make sure that the conclusions are supported by the data. And that's where a lot of experts fall down, because they can't support. They have a result they want to get. And if their data doesn't support the result, then it's sort of garbage in, garbage out. Does that help?
Yeah, well, it does, and I think my question then is, are you saying then that you'll only go so far in a Daubert analysis to say that the testimony is admissible? You still have to make the determination of whether there's a common question of fact that can be answered.
Right.
And you may say that the expert's testimony is completely valid and still come to the conclusion that the class shouldn't be certified.
That's exactly right. And it's the same thing in jury. So in class certification, the jury doesn't decide class certification, the judge decides it, but it's the same analysis, basically. So you can say that this is perfectly good analysis, but it doesn't answer the question yes. Sometimes it answers the question no, and in fact this class shouldn't be certified. The analysis is fine, but you don't win certification. I'm not going to strike the analysis. I'll consider it, but it doesn't carry the day. And that's the same thing I imagine a jury does. I'd love to be on a jury someday. I've done 100 jury trials. I'd love to actually be on the jury. That's what I imagine the jury's supposed to do, is say, okay, fine, we considered it, but it doesn't work. Same thing the judge does at the certification stage.
Okay, thank you.